The Honorable Deputy Speaker.
As we resume, I recognize the member for Chaguanas West. You have 8 minutes and 25 seconds to conclude your discourse. Proceed.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I indicated that I will deal with certain sections of the legislation prior to the tea break. First, I want to point to Section 6. There is no definition of what constitutes serious or complex fraud. This provision will clearly suffer from a lack of specificity, and it is ambiguous on a generous interpretation. How could one possibly frame criminal sanction legislation with such ambiguity? This provision will clearly be susceptible to being struck down by the courts. I now turn to Section 4, Clause 4, Mr. Deputy Speaker. Mr. Deputy Speaker, when you look at Clause 4, either party can elect to proceed to go to the master's level. So that so once the prosecutor elects to go to a pending matter, shouldn't the accused be given a right to consent? Why should the prosecutor be given this power, Mr. Deputy Speaker? And when you look at the Bajan legislation, which was recently passed, Mr. Deputy Speaker, it applies to matters that have not yet started. If a matter was commenced under the old law, it is allowed to proceed in that matter. Where a matter has started, the accused person, not the prosecution, makes the application to the court. The court makes the decision whether the existing matter will continue under the Act, not the prosecution or the accused. It preserves the right of the court to make the decision. So this is where a mature society like Barbados provides that. But in our situation, it is either the accused or the prosecution that elects. And what happens in a situation like that, it is loaded in favor of the prosecution, Mr. Deputy Speaker. So what is questionable in those circumstances is the fairness of the process under Clause 4.2, by which this new regime is introduced, and the potential for undermining the accused's right to a fair trial, including fair pre-trial proceedings. If both parties agree, Mr. Deputy Speaker, under the new law, so to speak, there would be no objection in principle. But where unilateral election takes place, it is almost certain to be the prosecution that makes that election. If the accused is content to proceed under the new regime, the prosecution is hardly likely to object because their task in securing the progress of the case to trial is much easier. To put it differently, it would never be unfair to the prosecution to offer a route to trial that is quicker rather than slower, and that involves less scrutiny of the case against the accused, not less. Mr. Deputy Speaker, so the question of fairness of the unilateral election provisions in Section 4.2 is in reality a question about the fairness of allowing the prosecution to unilaterally opt into the new act against the wishes of the accused. So that therefore, this has, the principle of fairness has practical implications for the unilateral election by the prosecution. Mr. Deputy Speaker, there is indeed an argument that allowing the prosecution to unilaterally terminate an ongoing preliminary inquiry is unfair to the accused. Mr. Deputy Speaker, by his own words, the Honorable Attorney General said that there were 43,000 preliminary inquiries as of July 2018. So therefore, the accused has no say in the matter if the prosecution decides to take the matter to go to the masters. We agree, Mr. Deputy Speaker, that there is no right to a preliminary inquiry. But if the accused and the prosecution have already embarked on a preliminary inquiry, the accused has a legitimate expectation that the process will be permitted to continue to its conclusion, and the evidence against him or her tested as envisaged under the whole Act. The longer the PI has unfolded, the stronger the complaint of unfairness. But there is an inherent unfairness in any case where an ongoing preliminary inquiry is prematurely terminated at the unilateral election of the prosecution. So, Mr. Deputy Speaker, so matters will be going on for years, and with this new law going to be proclaimed as quickly as the Attorney General indicated, then it will allow that to impact upon the accused. By allowing the prosecution to unilaterally opt into the new act facilitates arbitrary prosecutorial decisions, Mr. Deputy Speaker. There will be a natural temptation for the prosecution to exercise their unilateral right of election in cases where they are concerned that the preliminary inquiry might result in the discharge of the accused. So that you can abandon the process, Mr. Deputy Speaker. And we understand that there's no right to a preliminary inquiry. But what we see in this situation, Mr. Deputy Speaker, is that, to quote Lord Justice Fulford in the case of the Serious Fraud Office against Evans, 2015, 1WLR. In that case, Lord Justice Fulford emphasized that granting voluntary bills was an exceptional course and that the prosecution should not be permitted to treat committal proceedings as a dummy run. If Section 4, subsection 2 is brought into operation in its current form, the prosecution would be entitled to opt out of ongoing preliminary inquiries as a matter of course, or worse still, to prevent the discharge of defendants from ongoing PI inquiries on a targeted arbitrary basis. In other words, there's a provision that this provision is inimical to due process and undermine the fairness of criminal proceedings. For all these reasons, there are strong arguments, Mr. Deputy Speaker, of a constitutional principle in this matter, anchored in the accused's right to a fair trial and to due process, for not permitting the prosecution a unilateral right of election under Section 4.2. So, Mr. Deputy Speaker, the unilateral action and the power given to the prosecution in this matter, in my view, is contrary to the fundamental rights, Section 4 and Section 5 of the Constitution, and that therefore I believe that this is not good law before us. Whilst the principle of the elimination of PIs is a laudable objective, the reality is that it impinges in its current form on the right to a fair trial before the courts of Trinidad and Tobago. Mr. Deputy Speaker, I thank you with these few words.
I recognize the member for Laventille West.
Thank you. Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I'm very happy to have this opportunity to participate in this debate to amend the Administration of Justice Indictable Proceedings Act of 2011. So, Deputy Speaker, my colleague from Chaguanas West just concluded his presentation by suggesting to us that something or things about the measures in front of us this afternoon is inimical, a threat, an interference with the constitutional rights of the citizens. As all must observe, this bill does not require any majority. We are of the view that it does not touch and affect people's constitutional rights in the way in which he has put it, and therefore that has to be rejected. That's just another of the regular UNC story about good law and good law and good law, and it requires majority and so on. It was a feeble argument, and it has to be rejected. The measures here today, Mr. Deputy Speaker, as you know, and has been said before, very briefly, brought by his government, and therefore they have no real reason to disagree with this. To listen to about constitutional talk today doesn't impress me. It came from them, but of course, it is now the law of Trinidad and Tobago. It's on the books, and it has to be operationalized, and this is why we're here today. It, and the way they corrupted it, led to one of the most sordid experiences and a great blemish to the reputation of Trinidad and Tobago and, of course, the confidence of the citizenry in the system of justice. We really will take years to get over the events that transpired around this. But it takes us, we are here today, to put in place systems to give effect to this law, and, of course, there's good reason for doing it. It has been suggested by all, including the police, including the judiciary, including my friend who just spoke. Everyone would agree that the whole idea of removing the preliminary inquiry system, we call it PIs, but it's PE really, preliminary inquiry, it really, Mr. Deputy Speaker, is a good thing and has been described as laudable even by my friend on the other side. Because it was fraught with delays, serious delays over, you heard the statistics from my colleague, the Attorney General, and of course, fraught with danger as well. Fraught with danger. We've had examples of these delays, and I need not detain us with them. But at the level of the preliminary inquiry, the task of the magistrate was to determine not only to give the accused a chance to hear what is stacked up against him or her, but as well to determine whether a basic standard of evidence has been reached. They call it prima facie. Meaning that on the face of it, an offense has been committed, a person or persons have been identified with committing that offense, and that the ingredients of the offense have been established. And if those are demonstrated at the level of the preliminary inquiry, then it would be sent on indictment to the High Court, the assizes as we call it in the old days. Mr. Deputy Speaker, the trouble with this is that, as I said, it is fraught with delay and fraught with grave dangers along the way. Lawyers were able, after, the trouble with this is that you had to go through all the evidence, go through all this evidence in the court, almost like a full trial. So you ended up really having effectively two trials. One at the preliminary inquiry to deal with the prima facie case, and then an indictment that goes to the High Court, a full trial before a judge and jury in those circumstances. But at the level of the preliminary inquiry, the accused or the defendant, or through his lawyer, could make a no-case submission. And that was typically done on the R and Galbraith test, as all lawyers in practice would know. And that was a two-limb test. It's a long time I haven't had to deal with it, but I dealt with it when I was in practice as well, where the lawyer argued that there was not sufficient evidence to prove the ingredients of the offense, the elements that were necessary in the law in respect of that offense. There might not have been sufficient evidence to identify the particular person before the court with it. And the second limb of that test was whether, notwithstanding the fact that the ingredients were established, whether it was so weak, so tenuous, that no right-thinking judicial officer should commit the person on that weak or tenuous evidence, putting them at the risk of being convicted upon it. So it was that twin test known to us in Galbraith that was applied at this stage, and many cases passed that test and went on to indictment, and many, of course, failed on that hurdle. Of course, in that system, you had all the adjournments over years. You had lawyers unable to attend today because they have other matters in the High Court, and the High Court took precedence. You had issues with legal aid because we have a system of legal aid here where persons could have applied to the state for legal support. They will not hear a murder case unless the man is legally represented, just as they would hardly accept a guilty plea at that time. But today we have other arrangements in place. The police are with other matters elsewhere in the jurisdiction. Sometimes the prisoners are not brought to court for all kinds of administrative issues up there. So you had all of that. And then you had the danger that lurked. I remember dealing with a preliminary inquiry once, and once the accused, it was a double murder. I was there with now senior counsel Israel Khan, but he wasn't senior counsel at the time, and we are defending this fellow in a double murder that took place in the Santa Cruz area at the time. And when he listened to the evidence and saw that it was not looking like it was going in his favor, he got my attention and asked me, he had the temerity to ask me, Mr. Deputy Speaker, whether I would share with him the name and address of the prosecutor, the DPP's officer. That happened. And of course, as a good citizen, I did what had to be done to put an end to his dirty thoughts. But the point is, oh yes, they were dirty. They were dirty. Don't play no naive for me. You all know what that means, good. Yeah. You know more. Yes. So we put an end to that, Mr. Deputy Speaker. We had cases, we had a high-profile case. I don't want to go into names. High profile, where in my own terms, we lost our virginity in the business of criminal justice in this country. Where in a high profile matter, a file with the original documents went missing. And as a result, the case fell and never made its way to the High Court. Justice was never dealt with. In another case, which it developed in that time, this was the early 80s, I think it was, where the main witness for the state lost his life and therefore could not be there to give evidence. Again, that matter fell. It is with issues like that in mind that I make the submission that this system here was not only fraught with delays, it was fraught with danger. And then we saw a whole host of legislation, amendments to the very preliminary inquiries Indictable Offences Act, and many amendments to the Evidence Act, which works in articulation with the preliminary inquiries law, to plug these dangerous loopholes. Because criminals in this country felt that if you could eliminate the witness, either by killing him, by threatening him, and in some cases we had reports, and this should not surprise colleagues in this House, because in the United Kingdom, there are lawyers who are blacklisted by the state. The minute they show up in defense of someone in a police station, they are turned away because they are known to the state to be a danger to the state and the administration of justice. And we have some in every jurisdiction, and I'm sure Trinidad and Tobago too. Because there was a time when this very Preliminary Inquiries Act was used to subvert the system of justice in this country. There was a provision in it, and it has been corrected in the Evidence Act and in this particular bill, the 2011 Act, which we are amending today, it was corrected. Because in those circumstances where depositions, which is what you call statements, sworn to in the preliminary inquiry stage, when they were taken from witnesses, including state witnesses, and you're waiting 7 and 8 and 10 years for indictment in the High Court, in the intervening period, a lot of dangerous and dirty things were done. It is suggested that there were those who went to that state witness. They would have gone first to the accused and say, well, look, if you make, for an example, $500,000 available to me, the state witness will take $150, I will take $350, and we'll give you a ticket to go to the United States and never show up here again. We have had many cases that fell, and it was speculated among lawyers and among police circles, investigators. Things like that have happened here. Because the law at the time said if you, the prosecution, could not prove that the person was dead, and of course the person not dead, so you're not getting no death certificate. He's just gone. If you couldn't prove that he was too sick to travel, and how is the prosecution proving that? They don't even know where he is. He just disappeared. And then they wait, and when the matter is indicted and they come, they know the prosecution can't prove those things, positively prove them, and the matter just fell. And some bodies are richer, but we as a society suffered another major loss, another blow to the confidence in the justice system. The victims The family members go not having justice. And these are the kinds of things that provisions like we are dealing with today would resolve. And so, by way of an amendment to the Evidence Act, that was done in 2007 by a PNM government in responding to the problem that I've just told you. Evidence Act working in articulation with the Preliminaries Inquiries Act. At section 15B, it says in any criminal proceedings, evidence of criminal conduct which may be contained in a document may be admissible in evidence if the document A is the best or only evidence of that conduct which is alleged by the prosecution, and B is obtained by or under the hand of the Attorney General in mutual criminal assistance matters and so on. And 15C says, subject to subsection 2, a statement made by a person in a document shall be admissible in criminal proceedings as evidence of any fact of which direct oral evidence given by him would be admissible if it is proved to the satisfaction of the court that such a person is deceased, is unfit by reason of his bodily or mental condition to attend as a witness, is outside of the jurisdiction of Trinidad and Tobago and is not reasonably practicable to secure his attendance. In other words, the state must show that they made best efforts to bring him or get him here. D, cannot be found after all reasonable steps has been taken to find him. So again, you have to show now reasonable steps taken to find him, given its impossibility in some cases. Or E, is kept away from the proceedings by threats of bodily harm and no reasonable steps can be taken to protect the person. In which case, the statements can be used and the law and the amendments go on. All of it intended to solve the problems that we discovered in this country, and the measures before us today are designed to resolve some of those problems as well, not the least delay in the courts. As a matter of fact, Mr. Deputy Speaker, a son of Trinidad and Tobago, CLR James, told us that a surefire way, one of the best ways of knowing of a society that is in decay, is when we are unable to find solutions to problems as they arise. So we are here today dealing with solutions to the problems. Mr. Deputy Speaker, I didn't disturb my friend from Chaguanas West, and I know that he can find it in him sometimes to be courteous, and I trust he would allow me. So, Mr. Deputy Speaker, we are seeking, by removing the possibility of delay and the dangers that fell with it, to quicken the pace of justice, as the Honorable Attorney General told us. He did not tell you today, but indeed we have established the criminal division of the High Court. We have hired more judges, because I read the comments of the judiciary. We had the comments of the judiciary in preparation for bringing these measures, and the police, and the judiciary in letter dated the 28th of June highlighted the need for more judges and more courts in anticipation that the backlog, because the DPP tells us that he has about 600 indictments to be filed, you know. If he went ahead today and filed all, the bottleneck will move from one place to the next. And therefore we found it necessary. We found it necessary. And this is why we took an agreement from the UNC when we came to deliberate on this in 2011, that these things should be put in place before we gave effect to this law. That was the understanding. So while we voted for it, we voted with nobility of purpose, nobility of and good intention. But they corrupted it. They went behind the nation's back and they proclaimed aspects of it. And the laws we are bringing here today, the measures we bring here today are, if we remove the delay, for the benefit of every single citizen of Trinidad and Tobago, not for a handful of their friends. And that's the difference. So they took measures on that occasion, on Independence Night, to partly proclaim what should have been good law to free a few people. And we had to deal with it. So we have dealt with these matters. The Attorney General told us about removing these traffic matters and the plea bargaining law, all of which were either partly proclaimed or fully proclaimed, and we are moving on with those. as I told you, Mr. Deputy Speaker, we have another amendment to the Evidence Act, all to provide for video evidence and such matters, all with a view of quickening the process of criminal justice to make the system work better and therefore resolve the problems that we face. Not only Trinidad and Tobago is grappling with this, other countries too. Canada, as a so-called developed country, they have a constitution too, a charter of rights, and 11B of that charter in Canada talks about the right to a speedy trial, to paraphrase, or a trial in reasonable time to get closer to where they are. And some time ago, in the case of Aaron Jordan, the Supreme Court of Canada imposed itself on Canada. And in that matter where Jordan was charged for serious drug trafficking offenses, they took something like 48 months in the criminal justice process to convict Jordan. He filed a petition and argued that his right to a reasonably quick trial was infringed. And the Supreme Court of Canada upheld his application and dismissed the conviction and laid down two judges, I think one called, two judges of that court. Yes, one Mr. Moldova, Karikastanis, and Brown, two of them. They laid down some stipulations for the prosecution for the state arising out of Jordan and said criminal matters must be finished in 18 months. And if it is not finished in 18 months, concluded, there'll be a presumption that the Section 11, the Charter 11B right to a reasonably quick trial, a reasonable time, would have been infringed. And they are proposing that the state pay costs and compensation to the person in those circumstances if it is found that there was a breach of those rights. So Canada is grappling with this issue. That's not the end of it, because there is strong argument in Canada that while the law imposed itself on that way, there's a culture of delay in the courts, and that is what needs to be addressed. And this is why I commend these measures to the House, because the measures we have today, along with all the others that we have been identifying over the last few months, designed to quicken the justice process, is exactly what Canada is saying it needs now. Not just a judicial pronouncement, but actual activity on the ground in the courts, in the rules of the courts, and all of that, to deal with the issue of delay, which is what we are doing. And I want to congratulate the Attorney General, who I joined belatedly as he's embarked on this work. Well, yes, because by the time I got there, he had gotten a long way in dealing with this matter. And we are continuing that process. Barbados, too, Mr. Deputy Speaker, is facing an issue with this. Recently, in Barbados, they amended their constitution. A bill, an act, entitled an act to amend the constitution. Section 49. And this was done in 2019, very, very recently. And they amended, as I say, Section 8 as well, Section 84 of the Constitution. And hear what this says, in Section 3 of that provision. A judge may be removed from office only, this is existing law in Barbados, a judge may be removed from office only, A, for inability to discharge the functions of his office, whether arising from inability of body or mind or any other cause, B, for misbehavior, and interestingly enough, C, for delay of more than 6 months in delivering a judgment. Would you believe that? Because Barbados recognizes the importance of providing citizens with swift trials. We have had cases in this country, I don't wish to call a name, where a judge had a backlog of judgments for delivery for years. He resigned from the bench, he left and went abroad and would come intermittently to deliver judgments, seriously affecting people's rights. But fortunately for Trinidad and Tobago, after all those years, this is now behind us. And I only just went to Canada and to Barbados just to indicate to the listeners, the citizens of this country, that what we are grappling with here is not unique to Trinidad and Tobago, but we are seeing serious activity in this regard. Mr. Deputy Speaker, over the last 48 hours in this country, 8 prisoners broke out of the prison. We heard some commentary on it today. A very unfortunate state of affairs. Not unique to Trinidad and Tobago, but very unfortunate it happened. What was interesting is that for those, I think about 2 of them, who had an opportunity to communicate to the public, they argued that they did it, and I'm not accepting it to be true. I don't think it is justified, and I'm not supporting this in any way. But they positioned that it is the delay in their court process that prompted them to this. I don't accept that, but I understand what is being said. And I only bring it here to our attention to demonstrate to us that we have to remove even the semblance of that kind of feeling. We need to get on with it and make the system swifter and better so that we will not have people trying to use the delays that now are inherent in the system as excuses for that. Another person told me forcefully some time ago, Mr. Deputy Speaker, that it is the failure of the state to provide justice and justice on time that encourages people to take the law in their own hands. When I heard that argument, and when I heard it for the first time, it struck me. Because even in the Bible, people need justice, and we have to do things. So I asked my friends on the other side, rather than being obstructionists in this and other matters, let us understand where we are in Trinidad and Tobago, and taking direction from CLR James, work together to bring solutions to our nation's problems. And that way, we'll have a better Trinidad and Tobago. So you must support these measures, as we did these measures in 2011, though unbeknownst to us, you had a sinister purpose. So, Mr. Deputy Speaker, Pratt and Morgan, a matter that came out of Jamaica that lots of people would have commented upon. A brutal murder, I read the details of that case. But the bottom line is, the Privy Council, which is the highest court for Jamaica, as indeed it is, unfortunately, for Trinidad and Tobago to this day, and I'm taking the opportunity to say, our government fully supports the full jurisdiction of the Caribbean Court of Justice, housed here in Port of Spain, but we get no energy from our friends who at one time supported it, who negotiated to get it to be housed here in Trinidad and Tobago, fought very hard for it, but once things changed, and talking about change, earlier today, Mr. Deputy Speaker, in this house, we learned of they're telling us about something changed in a consultation with the President. I mean, I would like to thank the member for Diego Martin West for a very resonating presentation here today. I know the man is a geologist, but it was a mix. I don't know how he as a geologist also will describe it as a scientist, but it was a mix of earthquake, tsunami, volcano, hurricane, tornado. It was a political mix that blew the member for Siparia away.
A tectonic shift.
Oh, it was vicious, but it was founded on truth. Because we heard about change. What change? You supported the nomination of someone in this society to serve the country. As we serve here as parliamentarians, as people serve at different levels. What has changed? And if it changed since you did that support, did you write Her Excellency? No, you come here today empty-handed.
That motion irrelevance.
I'm flying past that. But I'm going past.
Overruled.
Oh, very, very nice. I thank you for your wisdom. Yes. So, Mr. Deputy Speaker, this is the kind of thing we are talking about. We have to approach this thing with a spirit of nobility. This is the nation's business. This is no game. This is serious. And they're paying attention to what we do and what we say. So I was quite pleased to see that concoction of natural forces in political garments blow the member for Siparia away. It was wonderful. And I would like to congratulate the member for Dago Martin West. Would you join me? Okay. I was telling you, Mr. Deputy Speaker, about Pratt and Morgan. Pratt and Morgan was a horrible case out of Jamaica, and it made its way on appeal, because the thing with even murderers, I practiced in the criminal court. I defended many a person accused of murder. Some we won, some we lost. I've had appeals in murder cases. And you know, what I have noticed is that notwithstanding our views on the brutality and the senselessness of the murder, the lack of compassion on the part of those who committed it in some circumstances, when the time comes for the hangman to attend to it, they appeal all the way and crowd for life. It's a natural human phenomenon. Nobody wants to die. So Pratt and Morgan made its way to the Privy Council in similar fashion, and the Privy Council imposed, as they did in R and Jordan from the Supreme Court of Canada, a 5-year limit on us in this jurisdiction, largely the English-speaking Caribbean countries. A 5-year limit. And to this day, so when this happened with Aaron Jordan with the 18 months, the Canadian government, I understand, spent millions of dollars refurbishing the system very quickly to get more judges, more courts, more all of that, in order to deal with the impact of that 18-month stipulation. And this is what the Attorney General and our department has been doing since we came into office. Not sitting down, not sleeping, not concocting Clause 34, not trying to find ways to give away legal fees and find up, instead of do so. Different. We spent our time getting the public work done. So, after all the years, since 1993, with Pratt and Morgan, we still have not been able to keep pace with 5 years as a limitation. So many persons are still coming into the system. They are still making their way through all the appeals to the Privy Council, still getting their petitions to the human rights bodies as they are entitled under the constitutional arrangements. And before you know it, the 5 years as stipulated in Pratt and Morgan is gone. But if we remove the preliminary inquiry, and as this law permits, to go through a sufficiency hearing by a master of the High Court, who by now have been recruited and are in office in place, then problem? Yes. Then we would make a dent in that 5 years, and we might have the opportunity, a fighting chance, as the Attorney General told us, to get swifter justice and therefore get people's cases heard. Yes, sir.
Your initial speaking time has elapsed. You have an additional 15 minutes. Do you care to avail yourself?
Most certainly, Mr. Deputy
Kindly proceed.
Speaker. Thank you very much. So, abolition of the Privy Council is critical in all of this. One, because it is antiquated and not necessary. It was born out of a time when you did not have rules for disclosure of evidence as they now have, where the accused could find out, other than in a preliminary inquiry, the cards that are stacked up against him and the allegations before the court. So it's antiquated, it is burdensome, it is costly, and it is, from all the evidence, unnecessary. I would like to add, it is also welcomed by the main stakeholders, the lawyers, because we have an opinion here as well from senior counsel elder who at the time represented the criminal bar. We have the views of the police, we have the views of the court, most of the stakeholders, and we have the views of the very recalcitrant UNC, because they were the ones who piloted
46-4.
Recalcitrant? 46-1?
Overruled.
Just for the benefit of my friend from Komuto Manzanella, recalcitrant simply means uncooperative. Good. And then why did you get up? It simply means uncooperative.
Member for Laventille West, I have ruled you, there's no need to prolong. Continue.
Thank you very much. Mr. Deputy Speaker, let me look in particular, I think the Attorney General did a very good job in analyzing the clauses of these measures, but I would like to look in particular at the offenses to which discharge on the grounds of delay would not apply. When this bill was debated and when it was passed back in 2011, we did have that Schedule 6. And Schedule 6 of the law, that is, it's not on the books, it's the law, as Act 20 of 2011, we had a list of offenses to which discharge on the grounds of delay would not apply. Because the provisions as they were there in that infamous Section 34 was to allow a person whose matter was at least 10 years old, I'm paraphrasing, and did not have their trial started, they could have made an application to the court to have these matters thrown out on the basis of delay. And of course, the matters listed in schedule that would not have benefited from that possibility would be offenses like treason, offenses against the person, namely murder, conspiring or soliciting to commit murder, manslaughter, shooting or wounding with intent to do grievous bodily harm, assault occasioning bodily harm, offenses involving kidnapping, whether it's kidnapping for ransom or negotiating to obtain a ransom, offenses of a sexual nature, whether it's rape, grievous sexual assault with a minor employee, buggery, and those kinds of things, drug trafficking, possession, unlawful possession of firearm and ammunition, attempts to commit offenses. I recall, because I was in the Senate at that time, we tried to exclude from the provisions in Section 34 what we called blood crimes. But it was when the fiasco came and applications were made and we had to rush in here Saturday to repeal that law after public outrage, when certain persons whose matters had gone to 10 years ran to the court, even before the law was made known to the printer. Somebody whispered to certain people and they ran to the court and applications were in the following morning, when the nation went in uproar against the UNC for doing the nation that. Then it was discovered that we should have added white-collar crime and complex fraud and money laundering and those kinds of offenses, because it was precisely the people who made the application, 10 or 12 of them, it was precisely for that type of crime that they were seeking the Clause 34, the Section 34 redress. So we have taken the decision and we have promised, as we promise again now, we will put that inside of that schedule so that we will be saying to the national community, this Parliament, that persons who are engaged in complex fraud matters and before the court, or white-collar crime of any description, money laundering, because we know this is done in billions of dollars and it is far more prevalent than some people might want to admit. In those circumstances, we will exempt them from it. So, Mr. Deputy Speaker, we have the distinction of tidying up for Trinidad and Tobago a conundrum and a mess that was set up for us in 2011. We consulted widely, and we are here. Some might ask, my friends, disingenuous as they are, why are you only coming now after 3+ years? Well, this is not the first matter of this nature we are coming with. We have been coming and coming and coming since we came to office, bringing laws to tighten up the platform and to make Trinidad and Tobago a less violent, a less corruption-ridden space. And we understand those who are intent on living by their wits and stealing from the public purse and interfering with things that are not theirs, we understand that it is not in all cases that they would support what we are doing, but we proceed notwithstanding. So, Mr. Deputy Speaker, I stand here as the Member of Parliament for Laventille West, and I assure you, having consulted widely with my constituents and having consulted widely with constituents and people all over Trinidad and Tobago, just to conclude, I went to the Borough Day celebrations and had a wonderful time a couple weeks ago. And while I was enjoying my pan and enjoying the ambience and the southern hospitality put on by the member for Point 14 and others, I'll tell you this, every 2 steps I made, citizens were coming to me and whispering how happy they are with what we are doing in this regard. So I do not only speak, and everywhere I go, whether it's in a funeral service, whether it's in the supermarket, whether it's on the sports field, wherever I go, the citizens of Trinidad and Tobago are appreciative of the government's effort to deal with white-collar crimes and criminals in this country and to establish once and for all the law is not made for some and not for others. So I stand here proudly to represent Laventille West in support of these measures. I think I can take the liberty on the basis of my anecdotal evidence a moment ago to stand in support of all Trinidad and Tobago and to say we support these measures. And I urge my friends on the other side to let good reason prevail and to support it equally as well. Mr. Deputy Speaker, I thank you.
I recognize the member for Point up here.
Thank you. Thank you, Deputy Speaker. I rise this afternoon to contribute a very short debate on my part because I don't profess to be a lawyer and I don't want to act as a lawyer today. To contribute to an act to amend the Administration of Justice Indictable Proceedings, Amendment Number 2, Bill 2019, Deputy Speaker. Deputy Speaker, we understand on this side the reason for these amendments, and it's really about improving the judiciary, quickening the pace of judgments, and clearing up the backlog, according to the Attorney General. But, Deputy Speaker, and I would not go over what my colleague, the member for Shogunas East, went into in his debate, but the Attorney General, sometime in January this year, when he brought amendments to this same act, the same bill, he talked about improvements to the judiciary by the amendments he brought in January, and it was passed, Deputy Speaker. But during his debate at that point in time and our contributions, we consistently asked the Attorney General about the improvements in the magistracy, the high courts, even the DPP, Deputy Speaker. And again today it was asked, because some months have passed and this government has been in place close to 4 years, and we keep asking the question, and I hope in the wind-up of the Attorney General that he can actually bring some facts of improvements to the entire judiciary system, inclusive of the DPP, Deputy Speaker. Deputy Speaker, I just want to concentrate on Clause 4 of the bill, Section 4 of the Act, which is Clause 4 of this bill. By the insertion of this new clause, subsection 3, subsection 2, shall not apply, and I read, A, in the case of a joint trial, unless 1, the prosecutor elects under subsection 2 in respect of all accused, or 2, all the accused elected under subsection 2, Deputy Speaker. Deputy Speaker, this is really about joint trials. And I really would like to ask the Attorney General, because this is a new subsection, in the fairness of individuals, because I think we still in Trinidad and Tobago, we are innocent until proven guilty. in the fairness of having joint trials, the prosecutor, from my understanding here, and I'm guided by the Attorney General, the prosecutor really is the individual, the DPP, in, I use the word approving, or is the one who is charged with deciding whether or not the trial is a joint trial, Deputy Speaker. And in the principle of fairness, I want to ask whether we should leave that amount of power in the hands of the DPP, Deputy Speaker, and not allow a judge to have that deciding factor on whether or not defendants or accused should be should have a joint trial or separately, Deputy Speaker. And this is, in my view, my humble view, that just this new subsection alone, in my view, infringes on the rights of Section 4 and 5 of the Constitution, Deputy Speaker. Deputy Speaker, I just want to refer, in respect to joint trials, in my little research in the USA, and I just want to read out an example, Deputy Speaker. You know, and the title is, in criminal cases where there are multiple defendants for a single crime, the district attorney, which is the USA, or prosecuting attorney, can build a charge under one docket number. This means that all defendants will be tried at the same time in front of one jury or judge. However, it goes on, it is often not in the defendant's best interest to be tried with the other co-defendants, particularly if one of the co-defendants have significant evidence against him or her. In order to prevent all the defendants being tried together, a criminal defense attorney can move a motion to sever. So in the US system, the criminal attorneys can move a motion to sever the trial from being considered a joint trial, Deputy Speaker. If granted, the motion will allow one defendant to be tried separately from the others. And this is under Louisiana statute law. And I want to just give an example that they gave. 3 defendants, and I quote 3 as an example, 3 defendants are charged with aggravated rape stemming from the same incident. Defendant 1, Deputy Speaker, cuts a deal with the district attorney and gives a statement implicating the other co-defendants. This defendant will testify against the other co-defendants at trial. The fingerprints of defendant number 2 are found at the location of the alleged crime, but there are no fingerprint evidence from the other defendants. If I am representing, I quote, defendant number 3, I would file a motion to sever so that my client would be tried separately from the other defendants. And Deputy Speaker, this is crucial because based on this new subsection that the Attorney General has brought here, it is really about the prosecutor, the DPP, having the sole authority to either have the trial joint or separate. Now, the accused, and it goes on, the Attorney General will say, well, the accused can elect under subsection 2. But if the prosecutor overrules that...
Remember, 1 second. Honorable AG, you will have your turn to... I apologize. So please, keep the tones down. Proceed.
Thank you, Deputy Speaker. And so that how it's worded here in the bill, Deputy Speaker, the Attorney General will say, well, the accused can elect to have trials separately, but the prosecutor has the overriding say, Deputy Speaker. And I think really and truly, it is something that I hope that the Attorney General will look at or even explain to us where is the fairness in that, Deputy Speaker. Deputy Speaker, when we look at the DPP and who is one of the office that really has the bulk of the work in trying to quicken the pace of these cases, Deputy Speaker. As we heard from my colleague, the resources, they need a lot of resources, and I hope that again, the Attorney General will not only do lip service, but actually put words into action, Deputy Speaker. Deputy Speaker, it is clear that this government is intent, and I really didn't want to join this debate, but the Attorney General in his opening debate called my name and pulled me in about pieces of the puzzle. And it is clear from my view, Deputy Speaker, that this government is intent on using certain pieces of legislation to carry out their mandate of political victimization, Deputy Speaker. As a layperson, I would even go far and say maybe Section 4 could be termed Ram Logan and Ram Dean. I don't know, I ask.
Again, members, please, let's abide by the standing order, okay? Let's abide by the standing order. Proceed.
And maybe even Section 6 could be called, airport or Asian Steve, Deputy Speaker. Deputy Speaker, as I said, the real purpose of this legislation is to improve the criminal justice system. And it is not about facilitating political persecution by this government, Deputy Speaker. But after 4 years, as I said, they have nothing really to show in the improvement of the district other than the pieces of legislation that the Attorney General, week after week, he brings here. And he really, as I said, putting the pieces of the puzzle together, Deputy Speaker. Deputy Speaker, I really hope that for me, the most troubling, besides the PI and so forth, is Clause 4, where I think the fairness has been removed on the hands of the DPP, and I mean no disrespect to the office holder of the DPP, Deputy Speaker. And I really want to understand, and I hope that the Attorney General, in his wind-up, can give me some clarity. Why would the power be put in the hands of the DPP's office to really determine whether trials should be joint or separate and not in the hands of the judges or the masters, Deputy Speaker? And Deputy Speaker, in those few words, I thank you.
I recognize the Honorable Attorney General.
Thank you, Mr. Deputy Speaker, it gives me great pleasure to put a reply on the back of the very sterling contribution of my colleague, the member for Laventille West, who really did yeoman service to this House in putting the context of the law. Much of the law that needed to be clarified by way of reply, my colleague has put onto the record in a very eloquent and intellectual fashion, and so I concur with much of the debate of my colleague, Minister Hinds. I am compelled, however, to answer a few of the observations coming from the members opposite. And I'll start with the member for Pointe-a-Pierre. You see, unfortunately, it also reminds me of the manner in which the opposition seeks to intervene in this parliament. A member of the opposition a short while ago rose on a standing order, quite confidently, quite robustly, invited you, the Honourable Presiding Officer as Deputy Speaker, to rule on Standing Order 46-4. Said with gusto, with confidence, with belief.
Cheering on the colleagues.
Colleagues cheering on. Colleagues in deep consternation as to why it had not been dealt with. And I put it in the context of replying to Pointe-a-Pierre now. You see, when the UNC members stand up, rise with confidence on a point, in this case, a standing order. Simple example. 46-4, Mr. Deputy Speaker. I read from the standing orders. 46-4 is the standing order.
We wind up on the debate, please.
Overruled.
Mr. Deputy Speaker, thank you. You see, I'm characterizing the confidence of the arguments coming from those opposite, and I'm pointing to the reality of what it really means. You know, there's this expression about certain vessels making certain sounds in a certain state of fullness or emptiness. And I put it this way, Mr. Deputy Speaker, as I continue my reply.
The disparaging vessels irrelevant. Except to him.
What? You think you're your wheels? What? Members? Overruled.
Thank you, Mr. Deputy Speaker. Confidence and gusto, 46-4, characterizing the argument of members opposite. Mr. Deputy Speaker, when you go to the standing orders, standing order 46 ends at 46-3. In other words then, there's no standing order 46-4. Now, why have I said that in the relevance of this? The relevance of that point is to demonstrate to the honorable members opposite and to the listening public through you, Mr. Deputy Speaker, do not be fooled for one moment by the confidence of the members opposite in the arguments that they offer. It reminds me, Mr. Deputy Speaker, of everything that the member for Chaguanas West pointed out. The member for Chaguanas West started off by saying that the Attorney General's submission, he characterized as one being a panacea for the ills of society. He then went quite confidently into saying that the Attorney General's office seems to be wearing rose-tinted lenses. But in fact, I think the Attorney General's office, whilst there's a positivity and a message that comes for hope based on the back of value, we recognize Hobbesian mentality, and look when we see it. Life is also poor, nasty, short, and brutish. Life is replicated in the persona of personalities that can stand in our society at times.
Member, let's retract, please, I heard. What's that you said?
The statement.
Oh, okay. I didn't hear the last part. Okay, sure.
You see, Mr. Deputy Speaker, when you're looking for the definition of poor, nasty, brutish, and life being short, sometimes the description fits more than just that which Hobbes was speaking about. So, Mr. Deputy Speaker, when we listen to the contribution coming from Pointe-a-Pierre, Pointe-a-Pierre went for a point of reference to the laws of Alabama. I was a little bit surprised that, sorry, not Alabama, Louisiana. Madam Speaker, I welcome you back. The member for Pointe-a-Pierre sought to persuade the Parliament that there was an appropriate formula to be rooted in the laws of Louisiana. As I sat here between two honorable members, one to my left and one to my right, I was reminded that the state of Louisiana is best known as the state of the law of Jim Crow. Lynching of people is what Louisiana is best known for, and Alabama, which is just next door, this week alone passed a law to say that doctors who perform abortions will be tried and convicted and be subjected up to 100 years in imprisonment, and a woman who travels out of Alabama, has an abortion in a state that permits it, when she returns can face 30 years in imprisonment. So when I listened to the source of law as an authority coming from Pointe-a-Pierre, I accepted then and there that the honorable member was truthful and honest in saying that he's a layman and will stay outside of the law. Because, Mr. Deputy Madam Speaker, I'll tell you why. The honorable member asked on a serious point. He was reflecting upon joint trials, and the honorable member went on to say, why give the DPP this much power? Why allow the DPP the ability to decide who shall face an indictment and who should face a summary matter? Because the election of persons in joint circumstances, the honorable member complained and then went to Louisiana to say, well, look, in Louisiana, they can separate out the matter. The honorable member made the submission that that was too much power for the office holder of the DPP. But Madam Speaker, I must and I'm compelled to point out that the authority for law comes from no greater place than the supreme law of the Republic of Trinidad and Tobago, which is our Republican Constitution, so described as supreme in Section 2 of the Constitution, and Section 90 of the Constitution, which sets out the powers of the Director of Public Prosecutions, deeply entrenched by Section 54 of the Constitution, says in clear terms that the DPP and only the DPP has the powers to institute proceedings, take over proceedings, and end proceedings. And there is no qualification of that right. But if one were to look further upon statutes, apart from constitutional source of authority, one need only go to the case of Hilroy-Humphrey, which is a Privy Council decision. And in Hilroy-Humphrey, we dealt with both the arguments coming from Chaguanas West and from Pointe-a-Pierre as to there being no fetter from a rule of law, due process, fairness aspect in changing the procedural approach to trials. And even in the abolition of preliminary inquiries, even in allowing the DPP that power which the DPP has constitutionally in Trinidad and Tobago in Section 90, the Privy Council has told us that there is no right to a preliminary inquiry. And similarly, one can extend that jurisprudential argument to the fact that there is no right to say that you ought to be tried separately or not at all together, because that power to lay prosecution is the DPP's power. So, Madam Speaker, I reject out of hand the submissions made by my learned colleagues opposite in relation to the DPP's square function of power, in the DPP's right to elect who should be charged and how persons should be charged, because, Madam Speaker, it isn't every matter, as a matter of fact, that the DPP says there ought to be a charge. In fact, the Trinidad and Tobago police have the authority to charge people, take them before the court to answer to a charge. It is only in respect of certain matters so defined by statute that the DPP's consent to prosecution is required. So this law, this Act of Parliament number 20 of 2011, has a very significant thing in it. And it is to be found in Section 3 of the legislation. Section 3 of the legislation refers to who can prosecute. And let me refer to this, and let me frame it now. The argument coming from Chaguanas West and the contribution coming from Pointe-a-Pierre is, this government has been in the saddle for 3.5 years, headed to 4. You've spoken about the criminal justice system. Tell us how you have improved the criminal justice system. Chaguanas West went as far as to say that of the 149,000 cases at the magistracy, Chaguanas West asked the government to speak to what has been removed from there. He went out to say that absolutely not even one case has moved from there yet. The honourable member also went on to talk about the fact of other operational issues, and I'm going to come to them one by one because it's important to deal with them. But let me start by saying that it is in the following improvements that I will answer the submission coming from Chaguanas West. Chaguanas West submissions were: 1, show me the proof of the criminal justice system beginning to work. The allegation was that the government is doing nothing and has done nothing. The honourable member went on to say that the plant and machinery of the courts, the plant and machinery of the DPP's office, the physical structures have been, according to the member, neglected by this government. The honourable member reflected upon Princestown, upon Rio Claro, upon San Fernando. Siparia, before she left the debate many hours ago, was egging the honourable member on to talk about the shift system and having a good chuckle about it, which I found quite interesting and which I'll come to in a bit. And then the honourable member for Chaguanas West went on to staffing at the DPP's office and then human resources at the judiciary, all of which need to be answered because they fit into Pointe-a-Pierre's position about the operationalization of laws. So let me come back to the point that I just left. In Section 3 of the law, I want to put onto the record, a prosecutor is defined. And a prosecutor is defined in this act as amended by us in January and then February of this year. A prosecutor includes the Director of Public Prosecutions, a person acting under and in accordance with his general or specific instructions, or for the first time in history in legislation, a police prosecutor, or in the case of a private prosecution of an offense, the person prosecuting that offense. The one that I want to single out here is a police prosecutor. I want to start with the human resource side of the police, because the honorable members opposite, in hearing the submission come from Point-A-Pair, which I'm very pleased the member put on forward. The member called this the Ramlogan-Ramdeen law and the Piarco Airport law, and I'm going to come to that in a second. In dealing with the human resource aspect, perhaps the population is not aware that this government went about reforming the criminal justice system by, first of all, seeking to declutter the system. Taking of the 146,000 cases in the magistracy, taking 102,000 of them, which are traffic offenses, out of the system. I am very pleased to say that we are approximately 2 months away from operationalization of the traffic division. That will result in the magistracy having greater focus. I am very pleased to say, Madam Speaker, that the government not only passed legislation to treat with subsidiary legislation the criminal proceedings rules to allow for case management for the first time ever, not only introduced IT technology for mask transcription and for CAT reporting, computer-aided typist reporting, as we have here in the Parliament. Not only did this government introduce a criminal division, criminal masters, the merger of two divisions, not only did this government open 2 criminal courts for children only, after having amended 23 laws on the first pass, 13 on the second pass, but this government, as a matter of fact, just up to yesterday at the cabinet, approved the complement staff for the magistracy. Why? The criminal division into which this law is going to operate, because once preliminary inquiries are abolished, the criminal division goes into full flight. The criminal division has been assented to since December last year. It is actively in operation. They asked for proof of cases. It is under this government that 400 maximum sentence indications hearings were heard, Goodyear hearings, which resulted in pleas of guilt. It is under this government that plea bargaining legislation was passed, assented to, and that history was made recently with a plea bargaining arrangement on the back of whistleblowers. It is under this government that the transmission of legal papers from the magistracy to the High Court happened in 1 day and not 1 year, as happened with the other 400 cases in MSIs. It is under this government that the first judge-only trial happened. We were told by the likes of Naparima, when we heard in certain contributions, huffing and puffing and looking like you need an oxygen mask to give you a submission, when we heard from certain people opposite, the venom that was poured, the definition and personification of Hobbes's view of the world, when we saw that argument coming, we were told, nobody will ever use the plea bargaining. Nobody will ever use trial by judge only, and especially for murder. Because the submission opposite was, who going to go before a judge only for a trial for murder when a jury could let you go? And yet, history was made by this government, by this judiciary, when Madam Justice Gillian Lucky gave the first acquittal with written reasons on a murder trial. History was made, again by Madam Justice Lucky, where the first money laundering matter was treated on a judge-only basis. They asked for one example. I've just given them hundreds of examples, Madam Speaker. But you see, the likes of Naparima wouldn't understand this, Madam Speaker. The likes of the argument of poor, nasty, brutish, and lacking in argumentative skills could never understand that when it comes from empty vessels, Madam Speaker. Madam Speaker, let's get on to a further thing that I was just saying. Under this government, Madam Speaker, the operationalization of the criminal division is critical. How does one operate a criminal division if the magistracy cannot replicate the success of the High Court in the civil division? In the civil division, where we have civil proceeding rules, where we introduced a whole case management structure, we took the backlog of civil matters from 17 years in arrears to 1. You can start in the civil arena, and inside of 1 year, your matter can be determined. So we've added in criminal proceedings rules. We've added more masters. We've divisioned the courts. We've added judicial capacity. But how does that work now if you don't have bodies to treat with it? What we did, Madam Speaker, we recognized that there are 13 district criminal and traffic courts, 3 criminal division locations. What we did, Madam Speaker, is that this government approved the following: 12 units with 217 non-standardized contract positions. Why? Because currently, Madam Speaker, 62% of the judiciary staff at the magistracy, let me repeat that, and Chaguanas West wants to know, 62% of the employees at the magistracy have no tenure whatsoever. None. 13% are OJTs, 12% are Ministry of Labor signed on 3-month rotations, 37% are temporary clerks who do not hold appointment in the public service, 11% are employed on contract, 5% are in the public service, 22% in the judiciary, the JLSE. Let me repeat that. 62% of the staff, as it lay fallow under the reign of senior counsel from Siparia, 62% of the staff had no tenure at all. So we bring the structures of the divisions, we pass as a cabinet, we underwrite the bill to the tune of $34 million a year, thanks to the Minister of Finance, approved and confirmed up to yesterday on the back of having passed the criminal division, implemented the structures, opened the courts. We have now brought judges and master support team, 25 officers, teams of 5 divisional judiciary secretaries, 5 judicial support officers, 5 associate judicial support officers, 5 divisional judicial orderlies, 5 judicial research counsel. Every magistrate will have teams like the civil judges have, judicial research assistants, judicial support officers, secretarial staff, transcription services, rules of court. What was the record under Siparia? 0. 62% under the senior counsel leadership of Siparia, 62% of the judiciary was effectively knocking from pillar to post without even a contract under their belt. And today, we have to listen to the honorable members opposite. But it's worse. You see, the UNC is best known for its need to have a coalition, because it can't face the PNM at the polls by itself. And in that coalition, Madam Speaker, in the context of this bill, in the context of the operationalization of the criminal justice system as this law will be grounded, it is not lost upon this government that the agent provocateur for the UNC is a gentleman named Watson Duke. And in that circumstance, the industrial action which prepares itself... He's a citizen. He's a citizen.
May I, Madam Speaker?
I wouldn't shoot my shoe on any pavement. Be afraid, man.
Madam Speaker. So, six.
Okay, so, excuse me, Prime Minister, I'm on my legs. You all have had a little time to breeze off. We now resuming, respecting the standing orders. Okay? Okay, what I'm saying is, quite many of us could give, but we can't take. This is a place of banter. I learned in primary school, people who can't, who live in glass houses don't peel stools. If you know your skin thin, my member for Laventille West, I know I'm a bit short, but I think I'm on the two legs that I have. Okay? So everybody now, control your tempers. AG.
Thank you, Madam Speaker. Madam Speaker, I'm saying, under Siparia, under the esteemed leadership of the member for Siparia, as a leading member of the bar, because, I mean, after all, if you're a silk, you are in the inner bar, and you consider yourself the pinnacle of the profession, deserving of higher grade of fees, etc. Knowing the judiciary well, the criminal justice system, the core of the argument from Chaguanas West, the babbling that comes from certain members in crosstalk opposite, and the contribution coming from Pointe-a-Pierre, is that the operationalization is key to this argument. I sat and I listened for the entire time. So when I am able to say today on behalf of this government, under this honorable Prime Minister, backed by this Minister of Finance, backed by a Minister of Planning, Madam Speaker, let me repeat that, under the coordinated management of a whole of government thinking, Madam Speaker. Let me put it this way. When I'm able to say 12 new units, 217 positions standardized, 93 classes of technical assistants, 68 divisional judicial support officers, 25 judges master support team, 84 standardized contracts, new units with witness support unit, bail management unit, 64 contract positions. Further on top of that, when all of that is put into effect, when I say, by way of my submission in answer to those opposite, that the agent provocateur of the UNC is the trade unionist, who is really a politician masquerading as a trade unionist in the form of Watson Duke, I'm saying, watch them with a cokey eye, a straight eye, any kind of eye you want. Because, Madam Speaker, it's tied into my answer to the next submission. Pointe-a-Pierre had the courage to continue the lost argument that Siparia had parroted through Naparima. And Madam Speaker, when we watched submissions a little bit earlier, Ole, don't use the English language.
Please. No, I mean, come on, you can't refer to anybody as a parrot.
You know, apparently members don't appreciate that there's a line between robust language and insulting language. I see, I rule, I over... No, I think this is Barataria San Juan. Barataria San Juan, maybe you should comply with your standing order 1. But, member for Pointe-a-Pierre, I overrule.
Thank you, Madam Speaker. Madam Speaker, let me repeat that. When one sees the parroted argument, there's nothing wrong with that. A parroted argument is one that you don't genuinely hold because somebody pulling the strings on you and telling you what to say. You're parroting an argument linguistically, intellectually. If you're incapable of holding an intellectual thought yourself, sometimes you may parrot something from a script or another piece of work. So, Madam Speaker, I'm speaking now that when we see this kind of operationalization funded, operated, in gear, it causes panic. But I was coming to the point. By my colleague for Pointe-a-Pierre, who I said had the courage, misguidedly in my view, I should call it, I can't be unparliamentary, so let's just call it courage. When the honourable member says that this law should be the Ram-Logan-Ramdeen law, Clause 4 should be the Ram-Logan-Ramdeen law. Madam Speaker, number 1, I am compelled to say that this law is for general purport. It does not infringe the classic Privy Council decision rendered in Lienage versus the Attorney General of Belize. It is definitely of general purport. The fact is that it can never be viewed as ad hominem. And Madam Speaker, I want to say why I reject this. Because the honorable member was very strident in his submission, you know. He said that, look, this law that this government is bringing now is the Ram-Logan-Ramdeen law.
It's true.
Hear it. Parroted, it is true from Naparima. Right. So let us accept their argument for what they say it is.
For 1 minute.
Let's put
For a minute.
that for 1 minute and let's respond as follows. Madam Speaker, oh shame ye that have little patience and ability, Madam Speaker. And let me put it this way. Without 23 brain cells opposite in certain aspects of the parliamentary debate. Madam Speaker, these amendments brought to us, I indicated in my piloting that it came from the consultation process which the Office of the Attorney General engaged in the view to operationalize the law. And what happened there, Madam Speaker? We wrote out who did we receive a submission from which caused an amendment to Section 4 of the Act? Let me put it on record now. Letter dated 6th of February 2019, addressed to the Honorable Faris Al-Rawi, Attorney General, Office of the AG, etc. Ray, the Administration of Justice Indictable Proceedings Act 2011 and the Administration of Justice Indictable Amendment Bill 2018. I have noted, etc., etc. She goes on, I've spotted essentially some fundamental flaws which have not been cured by the bill. By letter dated 17 July 2013, the Honorable Senior Counsel writes, addressed to then Minister of Justice, Ms. Chrislyn Moore, I identified some defects in the said act and requested that implementation be delayed until certain critical amendments were made. The Honorable Member on page 4, item 1, bold, capitals, starts off with Section 4, and then makes a recommendation to cause an amendment to Section 4 in pari materia in similar fashion to the one that we put here today. Now let me connect the dots to the Ram-Logan-Ramdeen argument. The senior counsel appearing for Anand Ram-Logan is Pamela Elder SC, and this letter written to me is from Pamela Elder SC. So Ram-Logan-Ramdeen clause, Naparima Boland, it's true, it's true.
No, it's 23 billion.
23 brain cell argument. Who writes the submission to point out to the need to amend Section 4 of the Act? None other than the lawyer appearing for Anand Ram-Logan in the very matter that causes them deep panic, deep pain, deep shame, and that causes some hope in the people of Trinidad and Tobago that maybe a court will find out what really happened. And I'll say no more on that. So, Madam Speaker, O ye with little patience, little confidence, and definitely less than 23 brain cells. Madam Speaker, this is critical to understand. But Madam Speaker, let's get to further operationalization. The Honourable Member for Chaguanas West asked what was going to happen with CLICO, Madam Speaker. And I'd like to say this now in the context of what I started off with. Could you ask Naparima to control himself?
General, your original speaking time is now spent. You have 15 more
Should it
minutes.
please you?
And I know as a very seasoned member of the chamber that you could rise above those distractions.
Sure, I could certainly rise above the intellectual argument, but the noise is sometimes troubling, Madam Speaker. So, Madam Speaker, the Honourable Member for Chaguanas West asked about the matter of CLICO, and it's tied in to the submission that I raised when I first started as to the definition of prosecutor, and it goes to the capacity of operationalizing this law. Madam Speaker, I can tell you that the prosecutorial capacity of the state has been importantly improved. Firstly, the Trinidad and Tobago Police Service, as Commissioner Griffith has pointed out, has birthed a first of its kind, unique unit where the best-in-class criminal prosecutors coming from the United Kingdom and elsewhere, experts in white-collar crime, joined by forensic auditors and forensic accountants and first-class investigators have met a team of similar worth, where Queen's Counsel from England, 32 forensic auditors and investigators and accountants have now all been clothed as Trinidad and Tobago Police Service members, allowing them to supplement the capacity of the Director of Public Prosecutions Office within the definition of Section 3 of this law, which allows them to prosecute. In other words, Madam Speaker, I understand why fear is gripping the members opposite. Because the prosecutorial capacity that has been put into place in this country has never had such form, substance, or impact. And I am informed by the Director of Public Prosecutions, and I verily believe that the prosecution and laying of charges in the Clico matter is imminent. So, Madam Speaker, let's go now to the rest of the Director of Public Prosecutions. Unfortunately for Chaguanas West, the DPP's office has been secured at Park Plaza, not Park Plaza, Park Street, accommodation that was once occupied by a bank. That particular property has been secured, outfitting is ongoing. San Fernando is to be located pursuant to the DPP's choice at the Gulf City Mall, and that office is being outfitted as we speak. Tobago Lowlands has been opened. So, Madam Speaker, 3 offices for the DPP, improve police prosecutorial capacity and investigative capacity to work on the prosecution side. But, Madam Speaker, the DPP staff, the JLSC, the Judicial and Legal Services Commission, filled all of the posts that they could. Every last post for Legal Officer 1 at the DPP's office prior to recent batch of publications has been filled. Legal Officer 2, Legal Officer 3, seniors and assistants are a matter for the DPP to recommend promotion on, and the DPP has nearly perfected that list. So what are you going to do when the DPP staff fills out the accommodation already acquired, cabinet decisions locked and loaded, implemented? What are you going to do then, honorable members? You see, we have not waited to perfect the DPP's office. We allow the Commissioner of Police, by his own direction under Section 123A of the Constitution, with sole management, to build out the TTPS prosecutorial capacity. But, Madam Speaker, that now feeds into the second line of questioning that Chaguanas West raised. What about the courts? And before Siparia left the chamber a couple hours ago, egging on the argument, there was laughter about San Fernando being in a shift system, like a junior sec, and what's happening, and Princestown closed, and Rio Clara has to take the load. Madam Speaker, I want to remind this population, the UNC government promised the judiciary that they were going to build judicial complexes. Yes. The judicial complexes were an undertaking given by Herbert Volney, who was demonized and fired and singled out for Section 34 in circumstances where the cabinet records demonstrate he was not the only man. He may have been the scapegoat for the Kamla Prasad Bisesa cabinet, which had the sole authority to proclaim Section 34, but he was not the only man. And Justice Volney, who then became Minister of Justice Volney, gave an undertaking to create judicial complexes. And what did they do? The UNC government promptly breached the Central Tenders Board rules, breached the procurement positions, and didn't build a single judicial complex. Worse yet, they went to the judiciary and they dismantled the entire facilities unit of the judiciary. They basically sent home anybody that could do repairs. San Fernando Magistrates Court was not repaired. It got worse. Anand Ramlogan, as Attorney General, caused the purchase of a property in San Fernando for part of the Magistrates Court. And guess what? The Ministry of Works condemned the entire structure. Cannot be occupied. Millions of dollars spent No accountability for it. And they're laughing about shift system. Didn't fix the court, didn't remove the asbestos, didn't cause any facilities unit to function, never delivered judicial complexes. When we came into power, first thing we did, we went into the magistrates' court and we started the retrofitting of the court. The earthquake came. The building was rendered unusable. The next thing that we did was to immediately take the land vested in the Attorney General's office at Irving Park by Sutton Street on that area there. That land has been vested in the judiciary and they are already finished with their designs to go out to tender to build a brand new magistrates' court. So while we build, while we organize, they, wheel, man and all, take pleasure in taunting the population, not telling them who caused the pressure, not telling them who had dereliction of duty, not telling them that they were celebrating up and down this country, aware of matters that are now before the police. Several members aware of matters now before the police. And we have to listen to them giggle, laugh, and make mockery of the suffering of people of Trinidad and Tobago, Madam Speaker. Well, I'll have no such thing as I stand here to answer on behalf of this government. And I stand to thank the Honorable Prime Minister and the Minister of Finance for underwriting the structures together with the Minister of Planning to arrange these matters. Now, I don't know what it is that causes Naparima so much difficulty, Madam Speaker. I don't know what it is that causes so much difficulty in the comprehension factor. But I go back to Hobbes. I go back to poor, nasty, brutish, and short in terms of ideology so espoused by one of the leading persons in jurisprudence. So, Madam Speaker, that deals with CLICO. That deals with the rubbishing of the Ramlogan-Ramdean clause, because little did Pointe-a-Pierre know the origination of the idea came from the lawyer for Ramlogan. So I don't know which one it is, left or right. I certainly will reject out of hand any categorization. Madam Speaker, you know, there was quite an interesting thing that came out of the UNC recently. I noticed in their publications as they go online that the honorable members sent out via the UNC machinery quite an interesting position. They were making this allegation that the current Office of the Attorney General has somehow spent more money than the Office of the Attorney General under Anand Ramlogan. They actually went, and here, again, I thank Naparima for acknowledging the 23 brain cell argument, right? The position is, Naparima says he agrees. So listen to this one. Listen to this one. The honorable members opposite in their machinery, which they think people say, they say this. Anand spent less than Faris, and I'm quoting from the webpage of former Minister Devant Maraj as posted. They aggregate the expenditure between 2011 to 2015. They say 5 years under the UNC, $1.25 billion. And then they aggregate under this Attorney General's office. They say this Attorney General has spent $1.34 billion. And Madam Speaker, for heaven's sake. Again, the half argument flows. First of all, under the Office of the Attorney General that Ramlogan ran, there was one ministry of the Attorney General. That one ministry had only the Attorney General's office. Under Dr. Rowley's leadership, we aggregated Ministry of the Attorney General together with the Ministry of Legal Affairs, which also absorbed the Ministry of Justice in large part. So this Office of the Attorney General runs 3 ministries, whilst they run 1. What happened further is that under the previous government, if you were to aggregate the fees that they actually had in total, when you look to the rolled up figure of
The Attorney General, this is not about the preliminary inquiries.
Attorney General. Please continue.
Thank you. So, Madam Speaker, in anchoring the functioning, the underwriting of the operationalization of this law, I'm answering the arguments, and I'm giving an example where the UNC says AG for AG. AG under UNC running one ministry. AG under PNM running 3 ministries. AG under the UNC, if you add legal affairs.
But it's still on.
Madam Speaker, if you aggregate the legal affairs, Ministry of Justice, and also the Ministry of the Attorney General, in fact, the UNC spent $5.5 billion, and this particular ministry spent $2 billion. So, Madam Speaker, any which way you take their argument, it's false. It is just false, Madam Speaker. Whether it is in respect of legal fees, whether it is in respect of the cost of operationalization of this law, Madam Speaker.
Relevant to what we debated. Why I can't get away with that?
Yes, Madam Speaker.
A minute. Member for Naparima, there's a certain imputation in what you said that is really a reflection on the chair. Now, you have a penchant for speaking in that kind of way, and I have ignored it. But it's becoming intolerable. I don't need any help. Okay? When I sit in this chair, I have a duty, just as you claim you have a duty when you sit in that chair. And I will demand the respect I deserve. Anytime you find you've had enough, there's an open door. No one has to sign or register to come in here or leave. I will not tolerate it anymore. AG.
Madam Speaker, I want to tie up the operationalization of this law into an example. You see, this law and this operationalization is about a concept. It can be confined and wrapped up and embodied in one word: value. What is your value in society? What's the population's value? What's the sense of value in this country? Let me take the example of legal fees, which will be spent in operationalizing this. Take the period 2010 to 2015. $1.6 billion, $1,000 billion, $1,000 million is $1 billion, $1.6 billion in legal fees. Let me tell you what the value of that is. If you spent $100,000 every day to try and spend $1.6 billion, it'll take you 44 years to spend that. Under the UNC, that's a small 5 years. 12 lawyers alone, 12 individuals alone under AG Ram Logan spent $260 million on themselves. And Naparima worried about 23 brain cells. Madam Speaker, you see, it's time to start.
When I'm standing, you sit. Nobody can leave while I'm standing. Okay? If you want to leave, you leave quietly. You don't disturb me. No, you have to wait till I sit.
Madam Speaker, you see, it's time to start calling speed, speed. And it's time to start pushing back.
Time is up.
I thank you, Madam Speaker. I beg to move.
Honorable members, the question is that a bill entitled An Act to Amend the Administration of Justice. I could barely hear myself. Honorable members, the question is that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. All in favor say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the administration of justice Indictable Proceedings Amendment Number 2, Bill 2019, be committed to the Committee of the Whole.
Honorable members, the question is that the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Whip, you have any amendments? AG, you have any amendments? So, okay? All right, thank you.
Clauses 1 to 11.
The question is that clauses 1 to 11 stand part of the bill. The question is that clauses 1 to 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 11 now stand part of the bill. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The House will now resume.
May I?
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I wish to report that the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act Number 20 of 2011, be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act Number 20 of 2011, be forthwith read a third time and passed. All in favor say aye. Aye. Any against? I think the ayes have it. Might I suggest that I have heard anything against? Clerk. I haven't heard anything but aye. Clerk.
What the division, Madam Speaker? I'm sorry for the record.
There's no right to division, Attorney General. I have heard aye. Clerk.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act Number 20 of 2011.
Leader of the House.
Madam Speaker, I beg to move that this House do now adjourn to Friday, the 24th day of May at 1:30 p.m. That day is Private Members' Day, and I would like to know what we'll be doing.
Thank you, Madam Chair. We'll be doing motion number 7 on today's order paper, which was brought by the member for Chaguanas East.
Sorry?
Motion number 7 by the member of Chaguanas East.
Thank you very much, Madam Speaker. I'd like to also indicate that we'll be doing the miscellaneous provisions, petroleum production levy, and subsidy income tax bill, which is on the supplemental order paper.
After 6.
On that same day,
Yes.
just seeking
Yes.
clarification.
That's what I'm saying.
You think you're talking about another thing? A real low IQ over there.
Honorable members, the question is that this House do now adjourn. All in favor say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, 24th May 2019 at 1:30 p.m.